welcome to What's the T in L&E. I'm Emily.
And I'm Leah.
We are management side employment attorneys with Rogers. And Leah, what are we here to talk about today?
We are talking about whether or not a manager can say something like, hey, if you don't like what's going on here at the company, you can go work for someone else.
I mean, that sounds pretty normal. Like, I've heard that before at work.
Yeah, oh, well, not here. Not here. Yeah, that does feel fair, right? But is there an issue with that?
Well, it turns out that there sometimes is. It depends on the context, and Starbucks found this out the hard way. So at a so-called collaboration meeting that Starbucks had with some employees on the heels of a lot of union discussions, their former CEO said to an employee, and if you're not happy at Starbucks, you can go work for another company.
And the NLRB, or the National Labor Relations Board, is the federal agency that carries out the National Labor Relations Act, which applies to even organizations that don't have unions.
Absolutely. It applies to you whether or not you have a union, because in the build-up to getting a union, there's often a lot of activity, and that's protected.
Yeah, employees have a right to discuss improving their working conditions, such as talking with each other about how they want to advocate for higher pay or change safety measures at the company. And so all of that is protected, concerted activity that eventually could lead to union organizing. And so the National Labor Relations Board in the Starbucks case said that Schultz's comments were threatening. They were borderline coercive. They essentially threatened employees that, hey, basically, if you don't like what's happening here at the company, potentially you can go work somewhere else, i.e. you should quit or your job is short-sighted.
So you can't threaten employees. There's a little acronym for this. I think it's TIPS, right? You can't threaten employees.
You can't interrogate them. You can't
intimidate them either, and you can't make promises to them.
Yep, and you can't surveil them. So you can't spy on them, essentially, when there is union organizing going on or conversations about this. Now, what can you do as a supervisor?
Well, you can share facts about the union. You can share your opinions about it. You can also share your own experience with unions, or just share your own job experience generally.
Yeah, but all of these things, there's a fine line and there's a lot of gray area. And so you really want to be careful. If there are rumblings going on in your workplace regarding union organizing, or maybe employees are talking about it because a federal or a local politician is campaigning on it during political season or election season, and employees are talking about, hey, should we unionize or can we unionize or whatnot, you want to make sure you get with appropriate labor counsel, because there are things you can and can't say during that time period.
Absolutely. Well, thank you for joining us for another episode of What's the T in L&E. We'll see you soon.